For those of you who haven't seen, I'm wearing, oh, it's not good. Oh, this doesn't pull. I'm wearing my Supreme Court shirt. Notorious RBG. Oh my goodness. I don't know. I don't think that'll work because oh. Well, just because they want to be able to see me, I want to be able to see my notes. Well, we'll work it out. Ruth Bader Ginsburg has become, as you know, a rock star of the Supreme Court, undoubtedly the very first rock star of the Supreme Court, and probably the last. So somebody made this T-shirt, and I got it several years ago, and I wear it to this presentation. I don't know how it's going to go. I forgot to bring a pen, and I'm not certain I can talk without a pen, so someone kindly loaned me one. And then I forgot to bring my water to the podium, but Gwen Ellen found some, so we'll see what else I forget. This is the fourth time I've done this SCOTUS presentation. For those of you who haven't been here before, or those of you who don't have spectacularly good memories, SCOTUS is an acronym for Supreme Court of the United States. And this talk is entitled SCOTUS October 2018 Term with a preview of the October 2019 term. The terms of the Supreme Court begin on the first Monday in October, and they are named for the year in which they start. So the October 2018 term started, I think, on October 1st of last year. And the October 2019 term started on October 7th of this year, about 2 years ago. The court usually finishes its work, that is, issuing opinions and decisions, in the June following the October in which it starts, though there is no fixed date for that, unlike the first Monday in October. Last year, in the 2018 term, the court finished on June 27th, 2019. And toward the end of June is when they usually finish. That's when the opinions that people have been waiting for, the controversial ones, tend to come out. So I will discuss a few of the cases, 2 or 3, depending on the time, that they decided in the October 2018 term. And it's not, obviously, it's not a comprehensive summary of what the court did, which is what you can get if you want to in a continuing legal education course. But this is, because they usually decide between 60 and 70 cases a year out of the 7,000 or so that are filed asking for review. So some people might think it's not a huge workload, but it keeps them busy. I usually give a preview of a few cases that will be decided in the current term, the one that just started. They usually accept cases up until January, so you don't know at this point in the year or in this term, nobody knows everything that will be decided or will be accepted for review. But they have already granted review in some cases about highly controversial issues, which will probably be decided in June of 2020, an election year. So I'll probably talk about more cases that will be coming up than I usually do. Let's see if this works. Yes, there they are. This is the official group portrait. They always do a new one when there is a new member, and of course Justice Kavanaugh, standing on the far right, is the newest member of the court. They sit in order of seniority. The court is very formal. Everything's done, well, not everything, I suppose, but many things are done on the basis of seniority. And they're very polite to each other, or so I understand. I've never sat in one of their conferences because nobody's allowed to, even the clerks, but they try anyway. So in the center, sitting down, is the Chief Justice, John Roberts, and he's the most senior justice, regardless of when he was appointed to the court. He could have been appointed yesterday, and he would still be in the center. To his right is Clarence Thomas, who is the most senior in terms of years served. To his left is the notorious RBG, Ruth Bader Ginsburg. To Thomas's right, next in seniority after Ginsburg, is Justice Stephen Breyer. And to Ginsburg's left is Justice Samuel Alito, who only recently got to sit down. I guess when Kennedy retired. Up on the top, the standing ones, Justice in order of seniority, Sotomayor, Kagan, Gorsuch, and Kavanaugh. According to Adam Liptak in the New York Times, this photograph is actually a composite, which their official portrait photograph has never been a composite before. Usually the photographer takes a number of pictures and sends them out to the justices and they vote, just like it were a case or something. But this time, I don't know whether they couldn't agree or whether they just, because the technology that was there, each of them got to pick whichever one he or she liked best of him or herself. So apparently, it's difficult to get a good picture of all of them. Justice Thomas, and this is all according to Adam Liptak, Justice Thomas, when he's in a position like this, sitting with his colleagues, tends to be very chatty, unlike when he's on the bench, when he almost never asks questions. It makes headlines in newspapers when Justice Thomas asks a question in oral argument. You know, oh, Justice Thomas asked his first question in 10 years kind of thing. But when he's posing for the photograph, he's very chatty. Justice Marshall used to fall asleep when he was sitting for a photograph, which doesn't make for a great photograph. So I guess they've come up to the 21st century in technology. They didn't say anywhere on their official website that this photo is a composite, but Adam Liptak is the person who covers the Supreme Court for the New York Times, so I guess he has sources. Before I start with case review, I want to mention a real-world follow-up on one of the cases that we talked about last year. That is a voting rights case. We talked about a couple of voting rights cases last year, and one of them was Husted versus the A. Philip Randolph Institute. That was a case from Ohio challenging Ohio's process for purging voters, for purging people from the voting rolls. And the question was whether it violated the National Voting Rights Act or the Constitution. All states purge voters from the rolls. You want to get rid of dead people, maybe unless you're in Chicago, I don't know. You want to get rid of people who have moved because people have to vote in the district in which they live. So all states purge voters. Some states purge the rolls of voters who are considered to be inactive. And Ohio has one of the strictest statutes for doing that. So Ohio's use it or lose it statute is what was challenged. And the court found it didn't violate either the National Voting Rights Act or the Constitution. So they went ahead, their statute remained in place and still remains in place. In September of this year, the Secretary of State of Ohio released a spreadsheet with the names and addresses of 235,000 people who would be purged from the voters' rolls in about a month from the time he released it. This was the first time that Ohio state officials had done that. Usually the purging is done in secret, and you don't find out you've been purged until you go to the polls to vote, and they say, sorry, you're not registered. They sent the spreadsheet to the League of Women Voters and other groups with an interest in the issues, and they looked it over and found that about 40,000 people, which is approximately a fifth of the people on the list, should not have been on the list. Among them were 40,000, among the 40,000 people, were nearly 20,000 people in Franklin County who were about to be purged because they were considered inactive. In fact, they had actually voted in the most recent Ohio election or the one prior to that, which even under Ohio's strict use it or lose it statute means they should not have been purged. Franklin County, where they found these 20,000 people, is a Democratic stronghold. The county seat is Columbus. So I don't know what's happened to the voter rolls in Ohio since then. This is very recent. Some people, I'm sure, will say that it shows that Ohio's law went too far, or at least Ohio's officials, the way they carried it out, went too far. issue, although this time this is a case from this term, but this next slide's going to look familiar to those of you who have been here before. One of the difficult things, I was going to say really bad, but I think difficult is a better word. One of the difficult things about doing this presentation is making slides. I'm not good at it, and it tends to take me maybe twice as long to make the slides as it does to read the cases and think about them. So I was very happy to be able to use this one again. In fact, this is the third time I've used it. And I'm sorry to say, you know, spoiler alert, I'm not going to be able to use it again because of the decision this term. Gerrymandering is manipulating the boundaries of an electoral district so as to favor one party or one class of voters. It's sometimes done on the basis of race, which in certain situations is legal. It's sometimes done to protect what are called communities of interest, which is also legal in some situations. And it's sometimes done to protect political parties. The picture is a caricature of probably maybe the first gerrymander, I don't know, but I guess the first one that got named was done when Elbridge Gerry was the governor of Massachusetts, and people thought it looked like a salamander, so they called it gerrymandering. It's drawing a district in very odd shape, or very odd, you know, almost not contiguous, or a district that has one or two houses connecting two parts of the district, things like that. Last year in my 2018 presentation, we discussed the case of Gill versus Whitford, which was decided on June 18th, 2018, which is why I just discussed it last October. That case was a challenge to Wisconsin's redistricting plan, the redistricting plan for the Wisconsin legislature, on the grounds that the legislators who drew the lines engaged in extreme partisan gerrymandering. Prior cases have not settled very much about partisan gerrymandering. 14 years ago, the justices rejected a case from Pennsylvania, a challenge to a Pennsylvania redistricting plan, 4 justices agreed that the court should decline to review partisan gerrymandering claims at all. 4 justices agreed that the court should review partisan gerrymandering cases. The ones who said that they shouldn't said there was no meaningful standard by which to judge whether something was too partisan. And Justice Kennedy, who was in the middle, agreed that the court should stay out of the Pennsylvania case, but suggested that the courts could play a role in the future if a workable standard could be found. So at that point, there were potentially 5 justices who would be willing to decide partisan gerrymandering cases. And as we talked about last time, many people thought that the Gill versus Whitford case would be the case where finally they would accept a case, they would review it, they would find a standard. The Gill plaintiffs suggested a standard. I'm sure you all remember the discussions of cracking and packing and all that stuff. We won't go through that again. In the summer of 2018, shortly after the Gill case was decided, Justice Kennedy, remember, who might have provided the 5th vote for considering these cases, retired and was replaced in the fall by Justice Kavanaugh. So in the 2018 term, the term that began in October of 2018, after Kennedy retired, they took up again a partisan gerrymandering case in 2 consolidated cases. One from North Carolina, challenging, these are both congressional, drawing districts for representatives in Congress. One from North Carolina claimed that the North Carolina plan discriminated against Democrats. They consolidated that with a case from Maryland that claimed that the plan discriminated against Republicans. So they found 2 cases that would not make them seem partisan, perhaps. The majority opinion was written by Justice Roberts on behalf of him and the 4 conservative justices. The dissent was by Kagan, Justice Kagan, joined by the 3 liberals. Roberts acknowledges that the maps in both states are partisan. And, from the opinion, the maps were described in the opinion as, quote, highly partisan by any measure and blatant examples of partisanship driving district decisions. So that was not an issue in the case. They were clearly partisan. They wouldn't even have had to reach the issue of if they were too partisan, because clearly, well, you can't say they were too partisan if there's no standard for judging, but it sounds as though if they could find a standard, these would be too partisan. But they couldn't find a workable standard, and therefore the issue of partisan gerrymandering presents a political question, and it's non-justiciable. The courts will not consider what they decide are political questions that are left to the political branches. So the federal courts, as a result of this case, will no longer consider any partisan gerrymandering cases. Sorry. Someone once told me you shouldn't apologize to inanimate objects even when you whack them. And I think that's true, but I do it anyway. So what they said is it's not justiciable. Justiciability is a concept that's created, well, it's created by the courts. There's nothing, but it derives from the Constitution, from the constitutional provisions that courts have to decide cases or controversies. It gives them jurisdiction if there's a case or controversy. And it refers to the type of matter that a court can adjudicate. A court can be considered non-justiciable, meaning the court can't hear it, if it would require the court to offer an advisory opinion, which is an opinion on an issue that hasn't really arisen yet. So if I go to court and say, well, if Congress passes such and such a law, it will be unconstitutional. I ask the federal court to rule on that. They'll say, no, that would be an advisory opinion. They haven't done it. There's nothing actually to rule on. We have no idea. So hypothetical cases are non-justiciable because they would lead to advisory opinions, which the federal Supreme Court will not do. The plaintiff must have standing, which means the plaintiff, for a case to be justiciable, the plaintiff has to have an interest in the outcome of the case, a real interest, not a hypothetical interest. So if I go into court in California and I say, California legislature is about to pass an income tax law that, I don't like, I mean, I'd make up some legal reason. And the court would say, well, you don't have standing to bring a challenge to this law because you don't live in California, you don't work in California, you don't pay taxes in California. It doesn't matter to your life what the California legislature does. Even if it matters as an intellectual exercise, the court doesn't deem that to give me standing to bring the case. The issues must be ripe, which overlaps a lot with advisory opinions. So they have to have developed to such, the issues have to have developed and the conflict between the parties to such an extent that it's ready to be adjudicated. There are not further things that are going to happen in the case. It can't be moot, which means that if something is moot doesn't mean in the law what it means in other parts of life. Moot seems to mean debatable, but in the law it means, no, this case is basically settled. I mean, the people have settled the case out of court, and so there's nothing to argue about, or something has happened, leaving nothing to argue about. That's moot in the legal sense. And finally, to be justiciable, the case cannot present a political question. It's up to the court adjudicating the issues to determine whether any of these things that would make the case non-justiciable are present. So the reason they decided it was a political question, partly, is that the Constitution leaves the apportionment and elections to the states and to Congress, which in the state legislatures really, so clearly political entities. And they couldn't find a standard. I mean, I don't know what they would have said if, well, they didn't, that's a hypothetical. That would be an advisory opinion, so I won't even give it. But they decided it was a political question because It's left up to the political entities to do the apportionments, and they can't find any standard by which to review them anyway. And the court doesn't like to review things if there's no standard, as we'll find out again later. But the Chief Justice Roberts does say that courts can examine partisan gerrymandering questions, state courts, excuse me, based on their own constitutions and statutes. And presumably they'll be able to find a standard, or perhaps they'll be able to find a standard. And he says that Congress could enact a statute prohibiting partisan gerrymandering, which is true. Congress could. The likelihood seems low. I think the first rule, although it's unwritten, of drawing electoral districts is protect incumbents. So it doesn't seem likely that Congress would enact a law prohibiting partisan gerrymandering, but you never know. So in fact, after Roberts said that the federal courts will not get involved, the North Carolina court overturned the districting maps that were at issue in this case on the grounds that they were overly partisan and ordered the North Carolina legislature to redraw them. The Republicans, who had been the ones favored by the old maps, said they would not appeal. So I don't know what's happened since then in North Carolina, but they are redrawing their congressional districting maps, possibly to make them less partisan. What they were doing before was drawing maps in such a way that they got, I think they have 13 representatives, and they made sure Republicans would have 10 and Democrats would have 3, even though voter registration is split almost evenly in North Carolina. Now, clearly partisan gerrymandering. So we'll see, you know, maybe they'll end up with 7 and 6, or maybe they'll just end up with, I don't know, 9 and whatever, 4, I guess. As a side note to the discussion of political questions that won't be reviewed by federal courts, there's a case called Nixon versus the United States in 1993, which was not President Nixon, but it extended the political question doctrine to lawsuits that challenge Congress's procedure for impeachment proceedings. Nixon was a federal judge, the chief judge of a federal district court, who was convicted of several crimes. The House brought an impeachment, brought articles of impeachment against him. He was convicted by the Senate and removed from office, which is the only way that federal judges can be removed from office. And he appealed to the federal courts, saying that one of the rules that the Senate had used in its impeachment proceeding was improper, unconstitutional, whatever. He lost. The federal courts it got up to the Supreme Court, and the Supreme Court said, no, impeachment is not justiciable. It's a political question. We will not hear cases about impeachment. Who knows what happens next? So we have the census case. Department of Commerce versus New York. This was a lawsuit that challenged the decision of Wilbur Ross, who is the Secretary of Commerce, to include a question about citizenship on the 2020 census. And you will recall it came up fairly close to the time that the census forms were supposed to be sent to the printer, because there are lots and lots of census forms, and the printer can't do them overnight. Can't take them to Kinko's. So they did get expedited review. They went to the district court, and then they got expedited review to the Supreme Court. The question was whether he violated the enumeration clause or the Census Act, which is a statute, or otherwise abused his discretion in asking a citizenship question on the 2020 census. That was the question of the case. The census, I'll talk a little bit about what the census is, although I'm sure, well, I hope, all of you have filled out census questionnaires. If you haven't, and you're residing in the United States, I'm pretty sure you're violating a federal law, so next time it comes, don't throw it away. The Constitution requires what it calls an enumeration of the population every 10 years to be made, quote, in such manner as Congress by law shall direct. That's Article 1, Section 2 of the Constitution, which you remember is the article about Congress, about the legislative power, and the 14th Amendment. The constitutional purpose of the enumeration is to apportion representatives in the House of Representatives. So to determine how many representatives each state is allowed to have. So after a census, the number of representatives a state has can go up or it can go down. After the 1980 census, Oregon got a 5th congressional district because of the population determined by the census. Many states have lost congressional districts, representatives, because people have left the state. So some of the Rust Belt states lose, some of the Sun Belt states gain. No state is allowed to go below 1. I mean, every state's allowed to have at least 1 representative in Congress. Wyoming, which I believe is the least populous state in the country, has 1 representative who represents the entire state. It's a big district to go door to door in. And he represents, and it is a he represents many fewer people than any single representative in California, New York, Texas, or any of the other populous states. There are these arguments about, well, their votes count more, the votes of people in Wyoming count more than the votes of people in California. I don't know. I mean, you wouldn't want Wyoming not to have a representative. Well, I don't think you would. Sorry, again. It's just automatic. It's like holding a pen when I talk. It's just my brain is wired. Who can say? So, in the Census Act, which is a statute, Congress delegated to the Secretary of Commerce the task of conducting the census, quote, in such form and content as he may determine. The Secretary is helped in this task by the Census Bureau, which is part of the Department of Commerce, and it's filled with statisticians and people who know how to take surveys and technical experts. The population count that's derived from the census is used not only to apportion representatives, but also by statute to allocate federal funds to states. So population matters if you want money, which every state does, to draw electoral districts within the state for state representatives. And in addition to a simple enumeration of the people, which is what the Constitution requires, it also collects demographic data, which is used for various purposes, such as grants and aid, urban and regional planning, business planning, academic planning, academic and social studies. So a lot of people use the census data for various things. Over the years, the census has asked questions about, for example, race, sex, age, health, education, occupation, housing, and military service. Also about radio ownership. That must have been so they could determine how many people listen to Armus Brooks. I don't know why else they would ask. Age at first marriage, native tongue. There have been 23 decennial censuses, from the first one in 1790 to the most recent one in 2010. 18 of them have asked at least some people about citizenship or place of birth. Place of birth, of course, is not a 100% indicator of whether you're a citizen. You could have been born in the United States and renounced your citizenship, or more likely, you could have been born outside of the United States but have been naturalized. But in any case, they asked sometimes about place of birth. From 1960 to 2000, most people got a short form census questionnaire, which did not include a question about citizenship. The long form, which was sent to a much smaller sample of the population, did include a citizenship question. In 2010, the form of the census changed again, and everybody got the same questionnaire, which was essentially the short form. It asked about sex, age, race, Hispanic origin, and living arrangements. Possil Q. I thought Possil Q came into the language before the 2010 census, person of the opposite sex living together, but I don't know. I don't remember. The questions that had previously been included on the long form, including a citizenship question, were asked in something called the American Community Survey, which was sent to about 2.6% of households. The Census Bureau and former Bureau officials have resisted occasional proposals to resume asking about citizenship on the grounds that it would discourage non-citizens from responding and lead to a less accurate count of the total population. Remember, the constitutional requirement is an enumeration of everybody living in the country, not an enumeration of citizens. It's an enumeration of everybody living in the country. In March of 2018, Secretary Ross announced that he had decided to ask a citizenship question in the 2020 form. He said he was doing so at the request of the Department of Justice, which sought improved data about citizens of voting age for purposes of enforcing the Voting Rights Act of 1965, something this Department of Justice has not been notable for, but you can always hope. Specifically for enforcing the ban on diluting the influence of minority voters by depriving them of single-member districts. This decision to add the question was challenged by a group of 18 states, the District of Columbia, various cities and counties, the U.S. Conference of Mayors, and several NGOs, non-governmental organizations that work with immigrant and minority communities. Now I'm going to take a little detour into administrative agencies, even though it might be boring. In some ways, the whole presentation really should be about administrative agencies because this case and certainly the next case are important administrative law cases. And administrative law is a very important branch of law. Administrative agencies are part of the executive branch. They're generally created by Congress, although in Oregon, they're created by the legislature. I mean, in states, all state administrative agencies are things like DMV, TSA, Internal Revenue Service, Department of Revenue, everything. They are charged with administering, executing, which is why they're part of the executive branch, the laws that are enacted by Congress, just as the president is. That's his duty to execute the laws, faithfully execute the laws, it says in the Constitution. Agencies have the power to make rules that have the force of law. They are subject to provisions of the Administrative Procedures Act, and I think probably every state has its own form of an Administrative Procedures Act. Certainly Oregon does. And the rules and the actions of agencies are generally reviewable by courts. Most people's, I think, I mean, I'm making this up, but it seems true to me, and that's the standard, right? I think most people's only contact or major contacts with government are with administrative agencies, with the DMV, with the TSA if you fly, with the Department of Revenue or the Internal Revenue Service, things like that. And if you have a business, with various regulatory agencies that regulate businesses. And when people talk about bureaucrats and get angry about bureaucrats, they are talking, I think, about people who work in administrative agencies. I mean, somebody called me a bureaucrat once. I was a legislative drafter for the legislature, and somebody called me a bureaucrat, and I was deeply insulted. So I think bureaucrat means people who work for administrative agencies, not people who work for the legislature. Another thing I could be wrong about. But the people who want to shrink government, to some extent, focus on administrative agencies. They don't like that an unelected agency head or unelected agency people have the power to issue rules that they have to obey. And you see a lot of this now, a lot of attacks on the EPA and other agents, on all kinds of agencies, that because people don't like the rules, they want the agencies to go away. So the issue of what courts can review plays into that in a sense. I will say, from my more than 30 years experience drafting bills, the legislature could not function if it had to put into a bill everything that administrative agencies, the kind of issues that administrative agencies deal with in rules. It'd be there forever, 24/7 for every day of the year, because administrative agencies adopt a number of rules. I once had to write a bill for the license plate, and this is something, nobody had ever written a bill saying what the color of a license plate has to be, but I had to write a bill saying that the color of the sky in the tree license plate in Oregon had to be blue. Well, that's something the agency should determine, but what happened was the agency was told by the legislature to develop a new plate to replace the Pacific Wonderland plate. And the Department of Motor Vehicles, along with the state police, because state police, believe it or not, have a significant interest in what a license plate look like. They want to be able to see it. So the license plate's main function is not beautifying your car. But the first license plate that they came up with, you may remember if you were in Oregon at the time, had a tree that looked dead, a brown tree, and this pretty ugly sky, and the state police loved it. But so the legislature got all bent out of shape and said, draft a bill that says the sky has to be blue. Well, if you had to do that kind of thing for everything that agencies do, you'd never get anything done. You couldn't do it. Legislators, legislative drafters don't have the expertise, for one thing. I mean, nobody in the legislature knew probably even that the state police had an interest in what the license plates looked like, much less how you would create a license plate that was easy for them to see from wherever they were. So administrative agencies are good, but they do make rules that people have to follow, and some people don't like that. Then judicial review of agency actions, which is what we're talking about in the census case and in the next case. The Administrative Procedures Act, as I said, governs agencies. The court has held for a long time that the APA embodies the basic premise of judicial review, that is, that it is lawful and correct for a court to review agency actions. Nevertheless, it's not available to the extent that a relevant statute precludes it. So if a statute that creates an agency or a statute that says what an agency can do says, and these decisions can't be reviewed, then with certain exceptions, they can't be reviewed. And if a statute says the agency has complete discretion about what rules they adopt, then that can't be reviewed, although again, that's only mostly true. When courts review agency actions under the APA, they're supposed to set aside those that are, quote, arbitrary, capricious, and abusive discretion, or otherwise not in accordance with law. So, Department of Commerce versus New York. We're back to the case, in case you forgot the census case. The first holding was that the enumeration clause of the Constitution, which, remember, requires an enumeration of everybody in the country once every 10 years, permits Congress to ask a citizenship question on the census and therefore permits Congress to delegate that to the Secretary of Commerce. That was Chief Justice Roberts and the so-called conservative justices saying, yep, you're allowed to ask the question. However, the court also said that in order to permit meaningful judicial review, an agency has to disclose the basis of the action, and a court can review that, although they can't set aside an agency action solely because it might have been influenced by political considerations. A strong showing of bad faith or improper behavior might justify setting aside an agency action. The evidence presented in the district court showed that the Secretary was determined to reinstate a citizenship question from the time he entered office. He instructed his staff to make it happen. He waited while department officials explored whether another agency would request census-based citizenship data. He subsequently himself contacted the Attorney General to ask if the Department of Justice would make the request, and he adopted the voting rights rationale very late in the process. The court said, quote, in the district court's view, this evidence established that the Secretary had made up his mind to reinstate a citizenship question well before receiving DOJ's request, and did so for reasons that are unknown but unrelated to the Voting Rights Act. And so, by a different majority, but also 5-4, the court held that the Secretary's action was ultimately arbitrary and therefore invalid because the sole reason he gave was a pretext. And that was the Chief Justice and the liberals. Interesting split on a highly politically charged case. So the Secretary was legally allowed to put a question on the census if he had a good, appropriate reason for doing so. The case was remanded to the district court, where they could have gone ahead and tried to provide a better reason. But the administration decided to stop the effort, and the census was sent to the printer without a citizenship question. It's very rare for a court to overrule an agency action on the basis of the motives of the agency head. Oh, well, yeah, this is one of those cases that had a lot of opinions, people in different places. I'm not going to talk about those parts. Kaiser versus Wilkie, also an important administrative law case. I'm not mostly going to talk about the administrative law parts of it because it has a very interesting and important discussion of stare decisis. The issue is whether two prior cases, Auer and Seminole Rock, Auer decided in 1997, Seminole Rock in 1945, should be overruled. Both cases, Auer and Seminole Rock, decided that a court examining the application of an executive agency's rule should give deference to the agency's interpretation of the rule if it was reasonable and, you know, obviously constitutional and all of that stuff. People have disliked these cases, conservatives particularly have disliked these cases for a long time. Seminole Rock was decided in 1945. It's been affirmed, used, cited many, many times since then, and was reaffirmed in a sort of major way in 1997 in the Auer case. So they call this Auer deference, giving deference to the agency's interpretation of its own rules. The so-called conservative justices of the Supreme Court have been arguing for years in dissenting opinions that Auer should be overruled and Auer deference should be discarded. Justice Thomas, in a dissent in 2016, said, "Any reader of this court's opinions should think that the doctrine is on its last gasp." And many people did think that. There were also law review articles about how bad it was, mostly from conservatives. So it was the case, Kaiser was the case in which many people thought would be the vehicle for overruling Auer and Seminole Rock. But a majority of 5 members of the court said no, we're not. The ruling was these cases are not overruled. A reviewing court must give deference to an agency's reasonable interpretation of its own regulations. Justice Kagan wrote for the majority on behalf of herself, the Chief Justice, and Justices Ginsburg, Breyer, and Sotomayor. The same interesting group of justices that we had in the census case, saying that the reason for putting the citizenship question on the census was a pretext. So it'll be interesting to see what the Chief Justice does next. The Kaiser case is, as I said, it's interesting and it's important for administrative law, but for our purposes meaning my purposes of being able to get through this, the really interesting thing is the discussion of stare decisis and the fact that the chief did not vote to overrule the prior cases, voted not to, not necessarily because he agreed with them, but solely based on stare decisis. Stare decisis is Latin, means to stand by things decided. And these are things that judges in cases have said about stare decisis. So stare decisis means you don't lightly overrule a case that the court has decided before. The things that you are standing by are cases, holdings in prior cases. So overruling precedent is never a small matter. Adherence to precedent is a foundation stone of the rule of law. Stare decisis promotes even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. Any departure from the doctrine demands special justification, something more than an argument that the precedent was wrongly decided. As you may know, and as we will discuss in the next hour, the court has already accepted an abortion case for this term. Both Justices Gorsuch and Kavanaugh were asked about their views on stare decisis in their confirmation hearings. Nobody would ask, and they wouldn't answer, a direct question about would you vote to overrule Roe versus Wade. It would be an inappropriate question, and they would say, I'm sorry, I can't answer that. But it's fair to ask how you feel about stare decisis, because that is a major principle for a Supreme Court justice. It has perhaps been assumed, since Justice Kennedy resigned and was replaced by Justice Kavanaugh, that a vote to overrule Roe versus Wade would be 5-4 in favor. With the Kaiser decision, perhaps the Chief is signaling that he is not so eager to mess with precedent. It's really hard to tell. But the fact that he was also the fifth vote in the census case with the 4 liberals is an indication of what I'm sure you've all read in the paper. He is reluctant. He does not want the court to be seen as a political body. He doesn't like the fact that judges are called Republican judges or Democratic judges, probably doesn't like the fact they're called conservative or liberal. He wants it to be seen as a neutral body. And I think he's, in the last few years, more than earlier in his term, trying to make that happen. So we'll see. Questions?
Good morning, Joan. Thank you for the refresher. This was most enjoyable. I have a question which goes back to the issue of agency interpretation of its, giving deference to an agency's interpretation of its own rules. If that case had gone forward and that principle had been overruled, would that not, in fact, have led to the complete politicization of every single agency, because every single agency is headed up by a political appointee of some sort who ultimately has the authority over agency rules? Would that be a reasonable interpretation of an outcome if that case had actually been overruled?
Yes. I mean, I don't know about every agency and every rule, but yes. But it also, if the case had been overruled, would have led to judges having more say. If they don't have to give deference to an agency's reasonable interpretation of a rule, then the judges are more free to come up with their own interpretation of a rule. And some of the people who have been grooming conservative judges for years would be happy with that. But yeah, I hadn't thought about it leading to more politicization of the agency rules. I was thinking more in terms of the judicial role being greater, and probably greater than most courts would want. But the agencies still, as in the census case, the Census Bureau part of the Department of Commerce was opposed to putting the citizenship question on, but of course they were overruled by the secretary, who is their boss. And you'd see, at least from reading the newspaper these days, a lot of agencies, most agencies have technical experts. And I mean, they have way more expertise. The the permanent employees, the civil servant employees of agencies have way more expertise in most cases than the political appointees who are the directors of the agency or directors of bureaus within an agency or something like that. And I think there's probably always, or maybe frequently, some kind of tension between those people. And I think that in some cases, recently, in the last few years, we've seen more of that tension than we usually see. So, yeah, I don't think we need more politicization of anything. Just my opinion.
Thank you, Joan. As always, thank you. This is Bob for everyone else. I should know the answer to this, or should recall it, but like you, I can't recall everything anymore, if I ever did. An agency's interpretation of its own rules. How, you did not state, and I cannot recall the answer to this question, where does that interpretation occur? And let me give you two choices. One, does it occur only in the argument presented in court by the agency? Or must the agency have established a prior interpretation in the court of, let's say, an administrative review or administrative decision interpreting its own rule? And the reason I ask that question is that if the deference was simply to arguments made by counsel for the agency in the course of litigation, the agency itself could zigzag all over the map. And it seems to me that the better answer is there must be some prior determination.
It never occurs in the course of litigation, and the court is very clear about that. In fact, usually it occurs when the agency applies a rule to a person or a situation or something like that. The Kaiser case, sorry, I think yes. The Kaiser case arose, Kaiser was a vet, and there was a question about benefits, retroactive benefits and things like that. So they applied their rule to him. And by the time it got up, I mean, it was a complicated fact pattern. And by the time it got up to the Supreme Court, what they were considering was the rule itself. But it started out as applied to him. And then you say, okay, is this a fair application of the rule to him? And then if you say, yes, you can say, well, but is the rule itself an appropriate rule for the agency? So it always arises in the context of something concrete. Well, I think always. Usually. You know, I'm a lawyer. Usually.
I'm going to ask you some questions about structure. How do you feel about efforts to increase the size of the court that have been mentioned? Should the proceedings, which are now, you can get audio of, be televised? And how do you account for the differences of opinion that don't always follow what they are supposed to in the script, conservative versus liberal?
Well, to answer the last question first, the reason that I say so-called conservative, and sometimes even put liberal or conservative in quotation marks, is that I don't think any of them is, well, I don't even know what the words mean in terms of the justices, except to define it by the kinds of cases, how they voted in certain cases. So I think it's sort of meaningless, and yes, they don't always vote as a block. Most cases decided by the court are not 5-4. And I didn't look up the statistics for the most recent term, but they will probably be available when the Chief Justice gives his report. I am opposed to packing the court. I am opposed to it because it never, I mean, people want to do it for a politically expedient reason, and that always backfires. It's like, you know, getting rid of some of the filibuster rule when the Democrats were in charge. Okay, the Republicans got in charge and they got rid of more of the filibuster rule. So I don't think that worked very well. Televising the court, from my experience in the legislature, I always hated it when they were televised because they grandstand. Possibly judges are less likely to grandstand, I don't know. So I guess I'm neutral. I mean, it would be interesting to watch. One of the things you would see, I heard a podcast about this, although you could also hear this in the arguments, if you listen to the oral arguments. Someone did a study of the number of times justices were interrupted by their colleagues. The female justices are interrupted far more often than the male justices. Big surprise.
Is that because they talk more?
Yeah, probably. I have this pen I could throw at you.
Thank you, Joan, for a sterling presentation.
Joan, this is Don. A couple comments first. I've noticed Roberts for a long time now. Every time Trump says something about his judges and the Democrats' judges, he pushes back immediately against Trump, and he's been giving more and more speeches, interviews outside of the court saying this is not a political body. So I'm kind of thinking that Trump isn't helping his case any by continuing to announce that information, because it looks to me like Roberts has to not only back up his words that it's not political, but when decisions are made that really change society, they're always known as by the Chief Justice's name, that this happened on under the Roberts court. The question has to do with your response to the packing of the courts. I would argue that packing has kind of been going on, is what's been going on, when the Senate refuses to even bring nominations up for the court when there's a Democratic president, and to save all of the openings then and until there's a Republican president. And I don't have the numbers off the top of my head, but I think it's been pretty glaring, the number that's there. So I think that's packing. What do you think?
Well, I assumed that Arthur's question, and certainly my response, dealt with increasing the numbers on the court. Packing in that sense, in the Roosevelt sense.
Okay. Hi, Joan. I want to ask about administrative agencies. If Congress, in its wisdom, feels that a given agency has overstepped its bounds or misinterpreted a given statute, does Congress have the right to pass a new statute, or does it have to wait for judicial review to kick in?
No, it absolutely has the right to pass a new statute. Whenever it, I was going to say whenever it wants to, but in these days, whenever it can, yeah. They have complete control in that sense. They can always override an agency action with a statute.
Okay, Joan, I think we're going to assume there'll be time for interaction within the next hour also, maybe?
I hope so.
So I know a bunch of you have other comments and questions, so let's take our break. Thank you very much.
You should do something, shout or scream or, I don't know. Jeanette, I'll try to look at you occasionally and see, and if you can't hear me, do something. Okay, part 2 is going to be cases that have already been accepted, some cases that have already been accepted for review this term, and these are cases on hot button issues. Well, you never know why the court accepts review of any particular case, but some of these are cases on abortion, guns, employment discrimination, religion, and they will most likely be decided in June of an election year. So we'll see. We'll see what they do. The first one I'm going to talk about is called, I think I just said this. Sexual orientation and transgender rights, guns, dreamers, unanimous jury verdicts, which has particular application to Oregon, although the case didn't come out of Oregon, and religious schools and state money. So those are, except for the jury verdicts, which I'm putting in here because of Oregon, those are hot button issues across the whole country. So the first one that I'll talk about is called G versus June Medical Services. And this is a case challenging a Louisiana law. This is the first time the court has tackled an abortion case since Justice Kennedy retired. The law requires that doctors who perform abortions in the state have the right to admit patients at a nearby hospital. So they have to have admitting privileges. The announcement that they would accept this case comes 3.5 years after the court struck down a law from Texas that was almost identical to this particular law in Louisiana. They struck it down by a vote of 5-3. 5-3 because there were only 8 votes because Justice Scalia had died by that time. Justice Roberts was in the majority with the other people that you would expect, except, of course, Kavanaugh wasn't on the court then, and Gorsuch wasn't on the court then. Texas had tried to defend its law by arguing that admitting privileges requirement was intended to protect the health of pregnant women. But Kennedy joined the court's four more liberal justices in holding that the state had not provided any evidence to show that, and that, in fact, the requirement made it significantly more difficult for women to get an abortion. The abortion providers in the Louisiana case have emphasized that the Louisiana admitting privileges requirements is virtually identical to the Texas requirement that the court invalidated. Moreover, if the law goes into effect, it would leave only one doctor performing abortions in the state during the early stages of pregnancy, and none after 17 weeks. The court has changed, as I said, since it struck down the Texas law. Justice Gorsuch filled the vacancy created by Scalia's death, and Justice Kennedy retired and was replaced by Justice Kavanaugh, neither of whom has voted on the Supreme Court on an abortion issue. Last February, in a late-night order, Chief Justice Roberts, who dissented from the decision in the Texas case that struck down the Texas law, provided the 5th vote needed to block Louisiana from enforcing the law while the litigation is pending. So the law in Louisiana has not gone into effect yet, because Justice Roberts and the liberals said, you know, you can't, this can't go into effect until after the courts have decided it. So that's a stare decisis issue. I mean, 3.5 years ago, they struck down a law almost identical to the one that's under consideration today. I wonder a little bit why they chose to take this case. Of course, they are not required to take any particular cases. There may be 1 or 2 exceptions to that, but abortion cases are not. So keep your eyes open, see what they do. Religion. Some of you may remember the Trinity Lutheran case, Trinity Lutheran versus Comer, that we talked about, I think in 2017. This is a step beyond that. The issue is whether the religion clauses of the First Amendment or the Equal Protection Clause of the United States Constitution invalidate generally available religiously neutral student aid program simply because the program affords students the choice of attending religious schools. That is, does a program which allows state money to pay for children to attend religious schools violate the religion clauses? Does striking down that law violate the establishment, the Free Exercise Clause, or the Equal Protection Clause of the 14th Amendment? You will remember the First Amendment says Congress shall make no law, ... prohibiting the free exercise of religion, or, no, this is in the wrong place, concerning the establishment of religion. So the two clauses are you can't make laws that establish a religion, and you can't make laws that prohibit the free exercise of a religion. Many state constitutions, including Montana's, have what's called a Blaine Amendment, named after James G. Blaine, the man from Maine. To one degree or another, Blaine amendments prohibit the use of state money for religious institutions or purposes. This is Oregon's Blaine Amendment, so-called Blaine Amendment. It's actually it's not an amendment to our Constitution, it's part of the original Constitution, Article 1, Section 5. No money shall be drawn from the Treasury for the benefit of any religious or theological institution. Sounds like a blanket prohibition. Blaine was an interesting guy. I mean, the only thing I really knew about him was this little James G. Blaine, the man from Maine. I think he might have run for vice president or something, but you know, I knew that his name was attached to these amendments. But it turns out his most prominent contribution to American political history was to further a particularly ugly form of discrimination. It was Blaine who channeled much of the generally anti-immigrant and specifically anti-Catholic feeling prevalent in 19th century American society into the state constitutional amendments that now bear his name. The Blaine amendments found in most state constitutions, including Montana's, resulted from his failed attempt to amend the United States Constitution. In the period following the Civil War, anti-immigrant sentiment, particularly against Irish Catholics, was running high. Many saw the newcomers as poor, uneducated, and loyal to a foreign power, in this case, the Pope. They were thus a threat to the American way of life. As a result, many Protestants wanted to ensure that Catholics had no influence in public institutions, particularly in public schools. Oregon, as most of you probably know, had a very anti-Catholic, has a very anti-Catholic history, and the Blaine Amendment is part of that, although it could sound, and does, on the surface, sound like separation of church and state. And it's still separation of church and state provision, regardless of the fact that it was initially aimed at Catholics. It still separates church and state. So the Montana program, which was enacted in 2015, allows taxpayers to receive dollar-for-dollar tax credits for donations to something called student scholarship organizations, which then awards scholarships to students attending private elementary and secondary schools. The tax credit, you recall maybe from the Cultural Trust. If you have a tax credit, you deduct the money directly from the taxes that you owe. So if you give $100 to the Cultural Trust, that comes directly out of the taxes you owe, rather than being counted for part of your itemized deductions. So it's a better deal than an itemized deduction. Well, I shouldn't say that I'm not an accountant and I don't know anybody's specific situation. In some situations, it's a better deal than an itemized deduction. So this, the taxpayer owes the state, this is the example given, say $100 in taxes. She can decide instead to send the money directly to the student scholarship organization, which will then spend it on private school scholarships. In practice, the tax credit program has served its unmistakable goal of funneling government dollars to religious education. The only SSO operating in the states supports 13 private schools, 12 of which are religiously affiliated, and over 94% of the program scholarships have gone to finance religious education. So that is, even though it's set up perhaps as an indirect contribution, parental contribution to religious schools, in fact, it's money that would otherwise go to the state. So it looks like a state contribution to religious schools. the state's Blaine Amendment, so-called no aid provision, was adopted to promote the separation of church and state and to ensure continued taxpayer support for public schools. And it expressly prohibits the government from providing direct or indirect aid for religious education. Because of that provision in the Montana Constitution, the Montana Department of Revenue enacted a rule that would bar these SSO scholarships from funding religious education and training at private religious schools. So pretty much cutting off the program, since 94% of the money was going for that purpose. Parents of the student challenged the Montana Department of Revenue rule. The Montana Supreme Court upheld their constitution, their constitutional provision, and struck down the whole program, abolishing tax credit funding for private schools in the state, whether they were religious or not religious. The plaintiffs, the parents in the case, excuse me, relied on the decision in Trinity Lutheran Church, which, as I said, we talked about a couple of years ago. That's the case in which a church had a preschool and a playground, and they, Missouri, came out of Missouri. Missouri had a program for giving grants to people for resurfacing playgrounds, because there was this much safer surface that could be put on playgrounds. And Trinity Lutheran Church applied for the grant, and they were turned down because they were religious, a religious institution. And the Supreme Court said, no, it's okay. This is a playground for a preschool. Resurfacing a playground is not a religious purpose, so it's okay to give that money to the Trinity Lutheran Church playground, church preschool playground. I think that the preschool was open to non-members of Trinity Lutheran Church. But the court was, in Trinity Lutheran, tried to make a narrow holding, and they said that the case involved only, quote, express discrimination based on religious identity with respect to playground resurfacing. Well, that's pretty narrow. There are not very many playground resurfacing cases that come to the Supreme Court, at least not that I've read. Now, I don't read them all anymore, so who knows? Yeah, and then they distinguish another case called Locke, which was also a religion case in which the state of Washington refused to pay for, the state of Washington had a scholarship program for graduate students who lived in the state, and I don't remember the details of it because it was, after all, 2 years ago that we did Trinity Lutheran. But in this case, the state, in the Locke case, the state refused to give a kid a scholarship, was going to do graduate study at a theological school. And they said, no, that's pretty much religious, unlike the playground. So we'll see. A lot of state constitutions, if the court finds in favor of the plaintiffs, a lot of state constitutions will have provisions that will then be considered invalid under the United States Constitution. States are allowed to have provisions in their own constitutions or statutes that differ from federal constitutional provisions. But something can be unconstitutional under the Oregon Constitution, but not unconstitutional under the federal Constitution. But I don't think something can be unconstitutional under the federal Constitution and still okay in Oregon. Pretty sure that's right. Virginia will tell me if it's not. Okay, it's right. The next case that they're going to talk about, by next, I mean the next one I've chosen, these are not going in order in which they're going to hear them or decide them, is the DACA case, Department of Homeland Security versus the Regents of the University of California. And there are two other cases, DACA cases, that have been consolidated with this one. Consolidated cases means the cases present the same issue, so they argue them on the same day, and usually usually I think they give a little bit of extra time for argument because they don't all have the same lawyers and stuff. So in 2012, the Obama administration established a program known as Deferred Action for Childhood Arrivals, DACA. Sorry, I can't actually see. If you can hear me, I can't see, so I have to pull this up. So, I mean, because you hearing me is more important than my seeing, except for the stuff I have to read. The DACA, the Deferred Action for Childhood Arrivals program, allows undocumented young adults who came to the United States as children to apply for protection from deportation, because as you know, everybody who's here illegally is subject to deportation. Applicants who meet a variety of criteria, for example, who have graduated from high school or served in the military and don't have a serious criminal record, must pay fees of nearly $500, submit, among other things, their fingerprints and home addresses, and undergo a background check. In the past 7 years, nearly 800,000 people have obtained protection from deportation under DACA, which permits them to work legally in this country and gives them access to other benefits like health insurance and driver's licenses. In 2017, the Trump administration announced that it would end the DACA program. In November, the Supreme Court will hear oral argument in a challenge to that decision. So the program was created administratively. It was not created by Congress. It's created by the Obama administration administratively, and now the Trump administration wants to abolish it also administratively. Well, yeah, Congress could, of course, but you know, that would be doing something about immigration. That doesn't seem possible. So the justices agreed to focus on two questions in this lawsuit about the DACA program: whether the Department of Homeland Security's decision to wind down the policy is judicially reviewable. Because again, this is agency action. Agency action is not automatically judicially reviewable. And two, whether the department's decision to wind down the DACA policy is lawful. That is, whether it's constitutional, whether it violates any statutes that are relevant to it, things like that. If they decide it's not judicially reviewable, justiciable, as we said last time, then they don't go further than that. The case is just dismissed or sometimes remanded to correct, if it's a standing error, to correct the standing. But this one, if they decided it was not judicially reviewable because the Department of Homeland Security had unfettered discretion, then it probably wouldn't even be reheard in a district court. I don't know that for sure, but I mean, the census case could have been reheard in the district court, but the Trump administration chose not to. So this is another case involving administrative law. It questions the scope of agency authority, the scope of judicial review, and by what standards are such actions reviewed. Guns. It's been a long time since there's been a Second Amendment case in front of the Supreme Court. I think about 10 years. The issue here is whether New York City's ban on transporting a licensed, locked, and unloaded handgun anywhere outside the city limits, including to a weekend home or shooting range, is consistent with the Second Amendment, the Commerce Clause, and the constitutional right to travel. In 2008, the Supreme Court ruled, so 19 years, excuse me. In 2008, the Supreme Court ruled that the Second Amendment protects an individual's right to have a gun, a handgun, at home for self-defense. That was the first case ever that had that interpretation of the Second Amendment. Since then, the Supreme Court has repeatedly declined to say anything more about how the states and cities, about how far states and cities can go in restricting gun rights. So this, as I said, this is the first gun case they've granted review in since the I think it was called District of Columbia versus Heller case, the personal right to own a handgun for self-defense. The request for review came from the New York State Pistol and Rifle Association and a group of gun owners who live in the city. What the city had done was enact a ban on transferring even licensed unloaded guns anywhere outside the city limits. So because of Heller, people are allowed to keep a licensed handgun in their home for self-protection, but the city of New York said, well, no, yeah, that's fine, you can keep it, you just can't take it anywhere. Except maybe outside, I don't know. The challenge on the Second Amendment is obviously on the right to keep and bear arms. The Commerce Clause affects interstate commerce, so I guess the city of New York was purporting to say, you know, I couldn't take my handgun to my home in New Jersey, which perhaps the challengers are saying is a violation of the Commerce Clause for the city to pass an ordinance like that. And the constitutional right to travel was years ago, I think even before I was in law school, or maybe while I was in law school, some state tried to put a residency limit on welfare benefits and said, you know, you can't come into our state and start getting welfare benefits. And the Supreme Court said there is, in fact, a constitutional right to travel in the United States, and a state can't limit that right by doing something like that. So the New York State Rifle and Pistol Association is arguing that this New York City ban also violates the right to travel. So the court, if it wanted to, would not have to do anything with the Second Amendment. They could say, yeah, this violates the Commerce Clause, or it violates the constitutional right to travel, and then we would not have any more interpretation of the Second Amendment, which some people think would be good and some people think would not be good. But after the court granted review, the city changed its rules. This New York City and New York State do not want the court reviewing this case. I think because they are, well, I think because I've read other people, better informed people who think because they don't want the Supreme Court to issue a Second Amendment opinion on this basis. So the city changed its ordinance so that licensed gun owners are allowed to transport their guns to, among other places, second homes and shooting ranges outside of New York City. Those rules went into effect on July 21st. And on July 16th, the governor of New York, Andrew Cuomo, signed a bill that changes state laws to allow licensed gun owners to transport their handguns to other places, again, such as second homes, shooting ranges, and shooting competitions, where they are legally allowed to have them. So the city asked the court to dismiss the case immediately because the changes to the city ordinance and the state law made the case moot. And you remember that moot means there's really nothing for them to decide. The city law no longer exists. People can pack their guns, you know, with everything else they're taking to their weekend home and travel merrily off to Connecticut. The justices refused to dismiss the case on the grounds that it was moot right away. That was, I suppose that was in July or possibly in August. In spite of the fact that they've stopped issuing opinions, they do actually do some work in the summer. They're just not generally meeting in Washington at the court. They scheduled oral argument for December, and they announced that the parties should be prepared to discuss the issue of mootness at the oral arguments. So they could still dismiss it after argument as moot, in addition to doing any of these other things. So we don't know at all. There's no way to predict whether it will be a Second Amendment opinion. Unanimous jury verdicts. This one will not get as much national attention perhaps as the others, but it will get attention in Oregon. Ramos versus Louisiana. The question is, does allowing a non-unanimous jury verdict to convict a person in a criminal trial violate the Sixth Amendment? Louisiana and Oregon are the only states in the country that allow non-unanimous jury verdicts in criminal cases. The Sixth Amendment is part of the Bill of Rights, of course. It's the Sixth Amendment to the United States Constitution. The court has held for a long time, well, at least since the adoption of the 14th Amendment, that many provisions of the Bill of Rights apply to the states through the 14th Amendment. That is, they are incorporated into the 14th Amendment. You will recall that we have a federal government and we have state governments. And not everything that the federal government does applies to the states. And the Constitution, particularly the Bill of Rights, did not initially apply to the states. The Bill of Rights limit what Congress can do, generally speaking. The First Amendment starts out, Congress shall enact no law. It doesn't say the states can't enact a law. But the 14th Amendment, which was adopted after the Civil War, is one of the so-called Civil War amendments, says this whole part of it, but the part that they use for the so-called incorporation doctrine usually is, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Those provisions of the 14th Amendment have been used by the Supreme Court to say, well, yes, even though the First Amendment says Congress shall make no law, it also prohibits states from making laws on those issues. And the same all the way through with most of the, actually the first 8 amendments, I guess, but not the Sixth Amendment. It has not been found to be fully incorporated yet to the states. By 1968, they had decided that they being the Supreme Court, that most of the guarantees of the Bill of Rights were incorporated in the Due Process Clause of the 14th Amendment, and so they were applied to the states. Duncan versus Louisiana was a case from 1968. Louisiana, in addition to allowing non-unanimous, Virginia told me at the break that I should not apologize to the mic. I should apologize to you all for that god-awful noise. And I think she's right. So I apologize for that god-awful noise. In addition to now allowing non-unanimous verdicts in criminal cases, Louisiana used to grant jury trials only where capital punishment or imprisonment at hard labor was possible. So those were the only times you could get a jury trial in a criminal case in Louisiana. Mr. Duncan was convicted of simple battery and was sentenced to 2 years in prison, and that was not considered sufficient to give him a jury trial. And the fact that the sentence could only be 2 years was not sufficient to require a jury trial in Louisiana. So in that case, Duncan versus Louisiana in 1968, the court decided that the Constitution was violated when the appellant's demand for a jury trial was refused. That is, the Sixth Amendment right to a trial by jury was incorporated, in that case, Duncan versus Louisiana, into the 14th Amendment and applied to the states. So the statute refusing a jury trial in most criminal cases in Louisiana was invalid under the federal Constitution. In 1972, in a case called Apodaca versus Oregon, the court ruled that the Sixth Amendment guarantees a right to a unanimous jury in federal cases, but that such a right does not extend to defendants in state trials. So that was a case about Oregon's non-unanimous jury provision. In that case, in that opinion, there were 3 different groups. 4 justices would have ruled that the Sixth Amendment does not require a unanimous jury at all, like even in the federal courts, while 4 others would have ruled that the Sixth Amendment established a right to a unanimous jury that applies in both state and federal courts. Justice Powell believed that the Sixth Amendment requires a unanimous jury for federal courts, but not for state courts. And he was the deciding vote. Last year, Louisiana repealed a state law that allowed criminal defendants to be convicted on a non-unanimous verdict. The state law never applied to capital cases, but it applied to other criminal cases. But that change applied only to crimes committed on or after January 1st, 2019. So crimes committed beginning January 1st of next year the defendant has to be convicted by a unanimous verdict. So on October 7th, the Supreme Court heard oral arguments, 2 weeks ago, in a challenge to the constitutionality of the non-unanimity rule filed by an inmate who was convicted of a 2014 murder. In recent years, the Supreme Court has turned down similar challenges, but both the court's decision to take up this appeal and today's oral argument, this was written by somebody from SCOTUS blog who was in the court listening to the oral arguments, suggest that the justices may be ready to strike down the non-unanimity rule, which is still in use in Oregon, once and for all. But complicating the debate over the non-unanimity rule is a broader, ongoing dispute over the importance of adhering to precedent, especially as controversial issues like abortion rights arrive at the court. So remember, they decided in 1972 that Oregon could have non-unanimous verdicts in some criminal cases. So now they are, in fact, being asked to overturn that precedent. There will be a lot of questions for Oregon if the court says you can't have non-unanimous jury verdicts. The first question will be, is that retroactive? Does that mean that Oregon has to reopen all the convictions of people that have been obtained by a 10-2 or 11-1 verdict? Because it has to be at least 10-2 in Oregon. And it doesn't apply under the Oregon Constitution to murder cases. And I have no idea how many people that is. But it might be a lot. And they might have to decide the retroactivity question because this guy in Louisiana was convicted in 2014. And so clearly, that's retroactive. I mean, if they decide now that he shouldn't have been convicted by a non-unanimous jury, then it seems as though Louisiana also would have to go back and look at all those cases again. So I'm sure there are people in Oregon's Department of Justice and, well, all over the Oregon criminal justice system who are apprehensive about what this might mean. Maybe some taxpayers might be apprehensive too. Okay, sex. Oh, did I say anything? Is there anything here? No, I already said that. That wasn't even supposed to be there. Now we get to sex. Because of sex, employment discrimination against LGBT persons. The question, there are 2 cases, well actually there are 3 cases, but 2 of them are consolidated with each other. Does Title VII of the Civil Rights Act of 1964 prohibit discrimination in employment based on sexual orientation? Those are the cases of Bostock versus Clayton County, Georgia, and Altitude Express versus Zarda. And does Title VII prohibit discrimination in employment based on transgender status? RG and GR Harris Funeral Home versus EEOC, which is the Equal Employment Opportunity Commission. Those cases have been argued. They were argued separately. Well, Bostock and Zarda were argued together because they present the same issue about sexual orientation. Harris Funeral Home was argued separately but on the same day because it presents the same question but about transgender status rather than about sexual orientation. Title VII of the Civil Rights Act. It's very important. The part that's pertinent here, it shall be an unlawful employment practice for an employer, ... because of such individual, to fail or refuse to hire or discharge any other individual, blah, 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 because of such individual's race, color, religion, sex, or national origin. What obviously emphasis added. I have heard through the years that when the Civil Rights Act was being discussed, it was, of course, race. It was primarily designed to prohibit discrimination on the basis of race, and that one of the Southern senators introduced an amendment to put sex in because he thought that was a big joke. But I recently read, in reading about this case, that that's actually not true, although because there were a lot of people lobbying on Capitol Hill to include sex in the Civil Rights Act, to include, banning discrimination on the basis of sex. So we'll assume good intentions on the part of Congress. But now the question is whether that includes discrimination on the basis of sexual orientation or discrimination on the basis of transgender status. Zarda was a skydiving instructor in New York who sometimes told his female clients that he was gay because he thought it would make them more comfortable when they were strapped to him for a jump. Okay. Bostock was a child welfare services coordinator for Clayton County, Georgia, who argued that after the county learned he was gay, it falsely accused him of mismanaging public money so that it could fire him. They both are alleging that they were fired because they were gay. Bostock's case was tried and appealed in Georgia, where the U.S. Court of Appeals for the 11th Circuit ruled that he was not entitled to relief because Title VII does not apply to discrimination based on sexual orientation. Remember, the country is divided into judicial circuits, and you have to bring a case in a circuit, usually, in which you live. So Georgia's in the 11th Circuit, and the 11th Circuit Court of Appeals, which is the highest federal court for the 11th Circuit, held that the Title VII did not protect Mr. Bostock. Zarda's case was tried and appealed in New York, where the Second Circuit Court of Appeals held that discrimination based on sexual orientation is, quote, a subset of sex discrimination and therefore is prohibited under Title VII. So in Georgia, you can be fired for being gay, and in New York, you can't be fired for being gay. So I guess, I don't know. Well, none of us work, so it doesn't matter. I guess that means we wouldn't have standing to bring a case. Both cases were appealed to the Supreme Court, and the Supreme Court had 11 consecutive conferences on these cases before they granted review. Conferences when the justices get together to discuss what cases they will review, and they get together to discuss outcomes after they've heard cases and everything. It is the secret proceeding in the Supreme Court. Even law clerks are not allowed. So they discussed these cases 11 times before they decided to grant review. It'd be interesting to be a fly on the wall, but I couldn't find anybody who was speculating. Well, I didn't look very hard, but. So Bostock and Zarda argue that the text of Title VII clearly applies to discrimination based on sexual orientation. Someone who is fired or otherwise the victim of discrimination because of his sexual orientation, in their cases for being men who are attracted to men, are undoubtedly fired because of their sex, because a woman would not have been fired for being attracted to a man. So they're fired for being a man. And a woman wouldn't be fired, for attraction to a man. And Altitude Express, the defendants in Clayton County, argue that all that Title VII does, well, not all, I mean, this is big, but is ban employers from treating employees of one sex better or worse than the other sex, and doing so because of their sex, because they're men or women. Amicus briefs, which are briefs from people who aren't parties to the case, friends of the court briefs, were filed on both sides. More than 36 supporting Bostock and Zarda, including one representing 206 large employers, including Apple, Facebook, Uber, Walt Disney, and Coca-Cola, who were pointing out that some people had said that this would be an enormous cost for companies, and these 206 large companies said no, it wouldn't be, and that it would in fact be good for them. More than 24 were filed on behalf of Altitude Express in Clayton County, including one from the federal government, which argued that banning discrimination because of sex only bars employers from treating members of one sex differently from members of the opposite sex. Oh, no, don't stay tuned yet. In the transgender case, Amy Stevens worked for 6 years as a funeral director and embalmer at the funeral home in Michigan. When she began work, she dressed and appeared as a man and went by the name of Anthony. But when Stevens disclosed in 2013 that she intended to live and work as a woman for a year and then have sex reassignment surgery, the funeral home fired her. The owner of the funeral home, Thomas Rost, later testified that he fired Stevens because Stevens was no longer going to represent himself as a man. He wanted to dress as a woman, which Rost, who is a devout Christian, believes would violate God's commands. So she filed a suit with the EEOC, and a complaint, excuse me. They investigated and found that it was a violation of Title VII. It was unlawful discrimination against her because of sex. The funeral home, the federal district court agreed that, or excuse me, held that Title VII's protections do not apply to transgender employees, but the Court of Appeals for the Sixth Circuit reversed that and said, yes, they do. So that's what the Supreme Court will decide. Her arguments on the merits were analogous to the ones made by Bostock and Zarda. She also argued that Stevens, this is the transgender woman, that the funeral home violated Title VII when it fired her because she did not conform to its owner's views of how men and women should identify, look, and act. And the Supreme Court has, quote, long recognized that discharging an employee because of the employer's sex-based stereotypes violates Title VII. And I didn't look up the case that was quoted from because I didn't have time. But I think these days, you probably couldn't fire a woman because she wasn't wearing a skirt, for example, unlike the olden days. So it's an interesting term coming up. These are just a few of the cases, probably controversial decisions on divisive social issues, likely to be decided in June of an election year. Stay tuned. Questions?
Hi, Joe. This is Bob again. In the New York gun case, one of the bases of the complaint was a violation of the Commerce Clause. Was that on the basis of field preemption? Because Commerce Clause is a grant of authority to Congress, and I didn't understand the nature of the argument.
I'm sorry, on the basis of what kind of preemption?
Field preemption.
I don't know what field preemption is.
It's an area which Congress regulates, and therefore no state can enact a law or subdivision.
Oh, yeah, I'm sorry. You know, I have not kept up with Commerce Clause jurisprudence, and so I really can't tell you that. I just know in the issues presented part, it said, you know, this violates the Commerce Clause, but I didn't, since they haven't decided the case yet, you know, there's no well, there were lower court opinions, which I was not going to read, that would go through all the arguments, but I can't answer that question.
This is Don. Question, the constitutional model has Congress making laws and the executive branch carrying them out. Presidents become frustrated and they issue executive orders, as in the case of DACA. The problem with those is, absent any congressional intervention, the next president that comes around can reverse the executive orders. Are there any general guidelines that say when a president is overstepping his or her authority in a certain executive order, or does each of these has to be decided on an individual basis?
I think they would have to be decided on an individual basis. because there's no, other than a court, there's nobody who can really just step in right then and say, you can't do this. And in order for a court to say it, somebody has to bring a suit. Now, Congress could, in every case, I believe, enact a law saying, no, don't do that. I mean, that's not what it would say. It would say, no, people who meet these DACA qualifications, for example, may still be deported. And so Congress could always do it in that way. I think in the travel ban case, when the Supreme Court finally decided it, they decided that at least one of the travel ban, or maybe it was a lower federal court, the president overreached his authority and unlawfully discriminated on the basis of religion, but that was a court. And then there were so many travel bans that I lost track of how they all got dealt with in the court. But I think the answer is no. There's no way other than Congress passing a law or somebody going to court.
This is Rosamond. I had a question regarding abortion. Is it ever considered that medical doctors should be making a decision about what care is needed for a medical procedure? To suggest that a law not related to people who are medical doctors would make this decision makes about as much sense as deciding how an appendectomy should be performed.
It has. That argument has been made. So far, well, on the federal level, I mean, Roe versus Wade, well, Roe versus Wade really leaves it to a woman and her doctor, but yeah, people have argued in some of, I think in some of the admitting privileges case that if the doctor thinks it's fine to do it without having to go to the hospital, then it should be considered fine to do it without having to go to the hospital. But the right is a woman's right. It's not the doctor's right. So most of the arguments are based on that.
This is Eric. I wanted to ask you a question. Aside from the issue of whether in criminal cases the jury verdict has to be unanimous, do you know what determines in the state or federal court system how many jurors have to actually be on the jury? Because I noticed in my practice over the years, the number varies, sometimes between state and federal courts or what jurisdiction you're in. And my overall impression is in recent years, there's been an effort, at least in the, with regard to civil litigation, to reduce the number of jurors in order to reduce the cost to the court system.
I think it's solely based on statute, although I can imagine, I mean, the Oregon constitutional provision that allows a non-unanimous verdict well, no, wait. It says it can be 10-2 or 11-1, so that must be a 12-person in a criminal case in the Constitution. In civil cases, I don't remember a provision in the Oregon Constitution that says anything, so I assume it's statutory, but I'm not sure. And I think that, you know, if statutes got it down too low, courts would say, no, that's not constitutional. That's not a jury trial if you have 2 people or 3 people, or where would they draw the line? I mean, I know there are 6-person civil juries, but no, I can't really answer your question.
Well, there's so much to be. I'm over here saying we've run out of time, but not out of interest, so please come back again.
Thank you. Thank you.